be compelled to obey processes of the Commission, like summonses and directives, and that when the former President appears before the Commission, he must answer fully questions put to him. The Commission also asked the Court to clarify the law pertaining to rights of witnesses who testify in its proceedings. Of particular importance, whether those witnesses are entitled to the right to remain silent and the privilege against self-incrimination. The former President decided not to oppose the remedy sought, despite the fact that the Commission also asked for an order directing him to pay costs of the application on a punitive scale of attorney and client. By a letter from his attorneys, he informed this Court that he would not be participating in the proceedings. He took this decision aware of the fact that if the Court were to be persuaded, the remedy sought by the Commission would be granted as it was not opposed. However, before the Court could adjudicate the Commission's claim, the latter was required to convince the Court that it was in the interests of justice that the Commission be given direct access to this Court. The Constitution requires that the rules of this Court must allow a person to bring a matter directly to the Court subject to two conditions. First, it must be in the interest of justice that direct access be granted. Second, the Court must grant permission for this to happen. In an attempt to meet these requirements, the Commission argued that in the circumstances of this case, it is urgent that this Court makes a final determination of the issues, because going to the High Court and thereafter the Supreme Court of Appeal would defeat what the Commission seeks to achieve. This is because that process would come to finality long after the end of the Commission's lifespan. This argument needed to be assessed in the context of the entire facts placed before this Court by the Commission. The Commission was established early in 2018, and it told us that since then, it sought without success that the former President appear before it as a witness. Despite issuing 2,526 summonses against other witnesses, the Commission opted not to issue a summons against the former President. Instead, he was invited to the Commission. No reason was furnished for this favorable treatment to the former President. The Commission was alive to the fact that the Constitution demands equal treatment of witnesses under the law. Had the Commission invoked its powers of compulsion quite early, the circumstances of urgency would not have arisen here. But even after it had become clear that the former President was not willing to appear before the Commission, and the latter had decided to compel him by summons, the Commission chose a very long route. Instead of asking its secretary to sign and issue a summons, in December 2019, the Commission gave notice of its intention to launch an application for the chairperson to authorize the secretary to issue summons. Needless to say, that this was completely unnecessary. Its secretary already had statutory authority under the Commissions Act to issue summons. Having chosen this route, which was opposed by the former President, the Commission failed to take steps timeously to ripen that application for hearing. That application was only set down for hearing in September 2020 and postponed to October 2020 when authorization was granted by the chairperson and eventually the summons was issued. The summons was duly served on the former president, directing him to appear at the commission in November 2020. It was during that appearance that the former president moved an application for the recusal of the chairperson. When it was dismissed, through his counsel, he informed the commission that he was withdrawing his participation. And if obliged to appear, he would simply come but would not testify. Thereafter, the former president and his legal team left the hearing without the chairperson's permission. This precipitated the Commission's approach to this court in December 2020. Quite clearly, the Commission is to blame for the situation it found itself in. But the question is whether, and despite the Commission's blunders, direct access should still be granted. This question arises because it is not the Commission's interests only which would be affected by a refusal to allow direct access. The Commission pointed out that there is a present public importance involved here, and that a refusal would prejudice public interests in the investigation of important constitutional matters. This is true. The former president is firmly placed at the center of investigations, which include that he had surrendered constitutional powers to unelected private individuals. The allegations investigated are so serious that, if established, a huge threat to this country's fledgling democracy would have occurred. It is in the interest of all South Africans, the former president included, that these allegations be put to rest once and for all. For these reasons, we conclude that direct access should be granted. With regard to the merits of the matter, the issue is whether the summonses and directives issued by the Commission must be complied with. Quite plainly, from the language of the Commissions Act under which these processes were issued, persons against whom summonses and directives are issued must comply with those documents. It is ironic that the directives were issued in terms of regulations made by the former president himself under the authority of the Commissions Act. The Commission itself was established by him in terms of the Constitution. It is therefore unacceptable that he is the one who frustrates its investigation. This conduct is in conflict with the constitutional order chosen by the founding fathers and mothers of this nation. We must remember that this is a republic of laws, where the Constitution reigns supreme. The former president's conduct is a direct breach of the rule of law, which forms part of that Constitution. In our system, no one is above the law. Even those who had the privilege of making laws are bound to respect and comply with those laws. For as long as they are in operation, laws must be obeyed. Regarding the rights of witnesses who appear before the Commission, we conclude that none of them have a right to remain silent. This right is available to arrested and accused persons and not to witnesses. However, Section 3, sub 4 of the Commissions Act extends all privileges enjoyed by witnesses in criminal trials to witnesses in proceedings before commissions. These privileges include that a witness cannot be compelled to give an answer which would expose him or her to a criminal charge. But it is the witness who must claim privilege against self-incrimination by demonstrating how the answer to a specific question would breach the privilege. This privilege is not there for the taking by witnesses. There must be sufficient grounds that in answering a question, the witness will incriminate himself or herself. In the result, the following order is made. 1, the application for direct access is granted. 2, Advocate Vuyani Ngalwana SC is not admitted as amicus curiae. 3, the Council for the Advancement of the South African Constitution and the Helen Suzman Foundation are admitted as amici curiae. 4, Mr. Jacob Zuma is ordered to obey all summonses and directives lawfully issued by the Judicial Commission of Inquiry into allegations of state capture, corruption, and fraud in the public sector, including organs of state. 5, Mr. Jacob Zuma is directed to appear and give evidence before the Commission on dates determined by it. 6, it is declared that Mr. Jacob Zuma does not have a right to remain silent in proceedings before the Commission. 7, it is declared that Mr. Jacob Zuma is entitled to all privileges under Section 3, sub 4 of the Commissions Act, including the privilege against self-incrimination. 8, Mr. Jacob Zuma must pay the Commission's costs in this court, including costs of 2 counsel. I hand down the judgment.